Good afternoon, good evening, good morning. 大家早上好。Welcome to the UN Global Talks on Generative AI and Human Creativity, co-launched in 2024 by Berkeley Asia IP and Competition Law Center at BCLT. My name is Hao Yuan, the hostess of this talk series. As today is the very first talk of this series, and we have a really diverse audience, so I want to firstly give a 5 minutes lecture on some of the basics of Gen AI and why is it so interesting to us IP scholars. Please bear with me for a moment if you find it redundant. So, as most of you know, the year 2023 witnessed generative AI getting widely deployed by the general public, even though the research on such tools can date back to as early as the 1960s. Compared with its older cousin, the analytical AI, such as the technologies used for weather forecasting and autonomous vehicles, Gen AI has this remarkable capability to produce new contents, be it texts, images, music, protein structures, or other forms, based on the patterns and information it has so cleverly gleaned from troves of data. From the appearance of these outputs, some can be found rather creative if we use the purely objective definition of creativity, firstly given by cognitive scientist and AI pioneer Margaret Bowden, meaning the ability to generate something new, surprising, and valuable. A typical example of such machine creativity with quotation mark is AlphaFold, who beat all the human players in 2020 and achieved a high accuracy rate of 92% in the context of 3D protein structure prediction. The two primary types of Gen AI we encounter a lot these days are one, large language models, LLMs, like ChatGPT, and two, text-to-image models, like Midjourney, DALL-E, or Stable Diffusion. Compared with human beings, these models are extremely good at reading patterns and finding correlations, connecting dots between all kinds of unstructured information in the data of yesterday. On the other hand, these models are not almighty, as some hypes want us to believe. As Turing Award winner Professor Julia Paul and Dean McKenzie explained in their seminal book, The Book of Why, this large language model-based AI cannot grasp causal effect between events, and thereby do not have true understanding of the real world. To put it simply, no matter how sophisticated these outputs may look, the so-called machine creativity is still largely based on this two-dimensional statistical relation prediction, which is strikingly different than our own creative process as a human being that usually embodies a unique personal link between the creator and the created. Perhaps not all technologies are double-edged swords, but AI certainly is. On one hand, because of this strong complementarity to human creativity, we are actually at the beginning of an important paradigm shift in the creative process itself. In that Gen AI can work as very efficient assistants or even partners in some situations to human artists and inventors in realizing our original conceptions. I call this synergy between this creativity enabling AI with human beings the central creators, as shown in this cartoon image, very cute, on the screen, on the right side. I borrowed this metaphor from Kasparov, the very first human chess champion that sadly lost to an AI, IBM's Deep Blue in 1997. So for those of you that are not familiar, Centaur is a mythological creature in ancient Greek stories, who is basically half human and half horse. If you recall, in the movie Harry Potter, it was Dum who saved young Harry from Voldemort in a dark forest in episode 1. Anyway, I found this image very on point because a centaur has a human's head and upper body, signifying that it is the human that finds and defines real-world problem to solve, be it technical or artistic. And meanwhile, the centaur has a horse's legs. So compared with traditional tools that were largely passive, Gen AI has much bigger space for automation in interpreting and implementing the human's directions. So it has much more horsepower than conventional tools like microscope or camera. And the tricky part is right here. Now the role of this rather proactive machine could be so significant to the output that at times some of us may not be entirely sure whether the final hybrid generation as a whole can be protected by the good old IP system, which has always aimed to incentivize and order human creativity and human creativity only. On the other hand, because of the appearance of creative contents generated by AI and its extremely efficient, high efficiency in generating them, particularly those commodity-typed pieces with low to modest quality, we see the machine has a scaring potential to displace a wide range of human artists, especially underprivileged ones, including painters, musicians, script writers, and even singers and actors. And as a last note, perhaps a bit ironically, some of the training data of this creativity displacing AI came right from these displaced artists in the first place. Despite all the intricacies of the legal doctrines, we can't help but wonder how fair is this kind of use in the so-called AI age. By the way, I always feel a bit uncomfortable when I use the phrase AI age, even though it's getting very popular these days. I feel strange because in my view, before the day AI really has its own sentience, we must not forget that no matter how sophisticated they seem, AI can only remain human beings' tools. And despite these tools' importance, the new age will continue to be a human age, empowered by a new, powerful machine, not vice versa. But in any event, what I just mentioned were but two common challenges faced by IP judges and policymakers in many jurisdictions today. Against this promising yet challenging backdrop, the purpose of this talk series is to explore the various aspects of the curious interplay of Gen AI and human creativity, trying to bring worldwide voices from scholars, policymakers, practitioners, and different stakeholders in the creative industries, particularly from Asia and the United States, to exchange ideas and hopefully build some consensus facing these common opportunities and challenges Gen AI brings forth to us. Regardless of our nations, legal systems, political beliefs, after all, we're all human beings facing the dawn of a new age. The theme for today is about one big challenge I just mentioned, aka the challenge to the authorship doctrine in China and the United States. In November 2023, a young and important local court in China Beijing Internet Court issued a landmark judgment, Li versus Liu, on the copyrightability of an image generated with stable diffusion. This is not the image of that case. Professor Cui will show you in a short while. This image was generated by me through DALL-E, by the way. The court found the human user that provided elaborate prompts to be the author. This judgment has triggered a flurry of vigorous debates in China and meanwhile garnered significant international attention. Some commented that this $70 ruling may have far-reaching implications on the evolution of AI-generated content in China, unleashing a trillion-dollar industry. Some contrasted this judgment with the rejection decisions issued lately by the US Copyright Office. The apparent disparity in outcomes, however, may have largely shadowed the similarity of a human-centered approach adopted by both institutions. In the following conversation of today, we will dive into the details of these landmark decisions and judgment in the two countries. We are very honored to have three distinguished discussants on this panel. Professor Cui Guobin from Tsinghua University School of Law and Professor Wang Qian from Eastern University of Political Science and the Law are two renowned IP scholars in China. Both often work as consultants for courts and legislation who will help us to see many nuances of this landmark case. We are also blessed with the presence of Professor Rob Murgis, co-founder of BCLT and co-director of Now Asia IP program. Needless for me to introduce a very well-respected IP scholar in both US and China, who will provide his insight from the lens of US copyright law, as well as some of the guiding principles of copyright. So without further ado, let's start now discussion for today. I'm gonna stop share this screen for now because Professor Wang and Cui might have some of their own images to share. So my first question will be directed to Professor Cui. Professor, would you please briefly introduce the recent Li versus Liu case to us? What was the major issue that the court trying to decide and the facts?
Okay, thank you, Dr. Hall, for your introduction, and very happy to be part of this event. Initially, I thought that we are not allowed to use PPT, so I don't prepare one for this discussion. Now I know that probably it's better to have one show to the details of the decision.
Yeah.
Okay, I will show you guys the English translation of the decision of the Beijing court. Okay, first I would like to introduce this case very briefly to the audience. I suppose most of them have already read some of the decisions, including the Beijing IP Court one. This case is probably I think that according to my understanding is the third case on AI issue in China, and probably the first one on generative AI here. In this case, the dispute work is a picture generated by stable diffusion. Here is I think,
yes.
Yeah, the picture in this Fig 6 is the dispute work. Initially, I think the plaintiff entered a set of prompts having about 50 English words. Here I show you the words here. Yes. Yeah, the plaintiff initially, according to the court's evidence, the plaintiff initially installed this kind of software, and then they enter into this kind of set of prompts. If you look here, I think that the words, the problem here is very general, right? Like extremely high quality and Japanese idol, highly detailed, symmetrical, attractive face, very general, right? That's the initial input. And then they also input a set of negative prompts, tell the AI system to avoid this kind of elements. For example, to avoid watermarks, username, or liquid body, or something like that. I think that probably 300 negative prompts. After they input this kind of prompts, and then the general change a little bit. I set some new value for some parameters here. For example, change the number of iteration steps into 33, and then the height to 300, the height of the picture to 37768, and also interesting here, I also configured the random seed to this number. Interesting. The court does not explain why they choose this kind of random seed. I think that probably when you use this kind of seed, could come out with two set of prompts and configure all these parameters. The plaintiff just click the generated button. They get this kind of picture, picture 3. And the plaintiff similarly is not satisfied with this picture. So to make a little bit change here, he keep most of the parameter unchanged, modify the weight of, I think the LoRa plugin tool. This plugin LoRa helped the system to, I guess, to draw Asian girl's face, right? So the not harmful girl. And then they change the value of this LoRa plugin, and then they resolved in this picture, the figure 4. I think that it's a very little difference, right? They probably change the color of the light and remove the hairpins or something like that. That's I think this one just like a mirror image of the figure 3, right? So the difference is very low. And then the plaintiff modify the random seed to this one. So you compare these two pictures, I think that's a jump, right? Here it's quite different from this one. And the court does not explain why they switch the random seed from the initial one to this one and then come up with this one picture. I don't think that's really have the same face, right? And then they change the parameter a little bit. They keep the parameter and add some additional prompt words, 7 to 8 English words like this one, and also very general, right? And then resolved in this dispute picture. So in general, I think this kind of picture was generated by two set of prompts and with some configuration of parameters. That's the dispute picture in this case. Okay. So in this kind of case, that's quite a few interesting copyright issues, like whether the work, this kind of dispute work follows into the scope of work of fine art and Chinese copyright law, whether the defendant infringes the right to attribution, because in this case, the defendant actually removed the watermark in the picture. So whether the removal of this kind of watermark is an infringement against the right to arbitration is also an issue here. And the third one, whether the plaintiff has a duty to disclose the fact that he has used AI in this kind when generating this kind of work, and also another issue is about how to calculate the damage for this infringement. So that's quite a few interesting issues here. For our discussion, I think the most important issue is I think two issues. The first one whether the AI developers' contribution here should be protected under the Chinese copyright law. The second one is whether, probably more important one for today, whether the AI users' contribution make the work original one, right? So Dr. Hall, I need to introduce the court decision on these two key issues now.
Actually, I think for today, maybe we just focus on the users, the court's finding of the users. Or if you could
Okay.
they talk about the AI developer, that's good too. But very briefly.
Okay. Okay. For the first issue, as to the AI developers' contribution, I think the court rely on the Article 11 of the Chinese copyright law, which states that an author is a natural person who create a work, and also under some exceptional situation, a legal person or an incorporated organization could be viewed as an author. So the court believe the law require also should only be a natural person, a corporate or an unincorporated organization. Therefore, artificial intelligence model cannot be deemed as an author here. So that basically means a machine could not be viewed as an author. I think that's a doctrinal analysis, right? Many courts in this world follow the same logic. So it's for me, I think it's acceptable. From the public policy perspective, it's also very clear, right? There's no need for us to incentivize AI developers to do this kind of things. So that's the first issue about AI developers' contribution. The second one is all about the AI users' contribution. The court believe the case like this, when we are dispute on the originality, we could only adjudicate or decide this kind of dispute case by case. Here, the court believe the plaintiff input prompts and set the parameters, and then get the first picture. Probably the court also here believe the first picture generated by the AI automatically is not protectable. But the court emphasized then when he added some new prompts and modified the parameters and finally got the picture involved, such an adjustment or modification should reflect the plaintiff's aesthetic choice and personal judgment. So the picture involved meets the elements of originality. And also, I think the court made some kind of a policy argument. He said the generative AI technology has changed the way people create, just like many other technological advances in history. The process of technological development is a process of outsourcing human work to machines. The core purpose of the copyright system is to encourage creation, and creation and AI technology can only prosper by properly applying the copyright system and using legal means to encourage people to use this kind of latest tools to create. So, again, this kind of background, as long as AI generate image can replay the user's original intellectual investment, they should be recognized as a protectable work under copyright law. That's a court conclusion for the second issue. Okay, I stop here and
thank you.
That's.
Thank you very much, Professor Cui. So because I just saw audience having a question, I might just need a quick answer. So the court didn't really talk about the AI developer if it's qualified by author, right? It only said that AI as a machine cannot be. Do you have an impression if the court say the AI developer can't be the author either because of some reason, like?
Yeah, here I think that the court only say the AI system itself is as a machine could not be viewed as a author, but whether the developer's input or contribution when creating this system could be protected under copyright law. I think it's not a issue here, right? Because the developer is not a party of this kind of dispute. So the court,
right.
I think, deliberately avoid jumping this kind of issue. Actually, I also have a discussion with the judge previously, so I know why they avoid this kind of issue.
Right, that's a really good point. So yeah, the judge actually the presiding judge of this case, Judge Zhu Ge, a very impressive woman judge. I had several conversations with her, and she can't be here today, but she would like to read just 2 paragraphs she wrote as a statement from the court. It's an all-women panel, very impressive from my point of view. Anyway, just give me a few minutes here. I'm gonna read it. So the translation is my own, so all the errors are mine. Generally speaking, the originality requirement demands an independent creation by the author, which embodies the author's personal expression. When it comes to using AI to generate images, whether it embodies the author's personal expression needs to be evaluated in the individual case, and there should be no categorical rule. The rule of thumb is when people use models like Stable Diffusion to generate images, the more distinctive the user's demands are compared with others, the clearer and more specific the user's description of the specific painting elements and layout of the image, the more it will embody humans' individual expression. In this case, during the generating process of the image at issue, the plaintiff made a range of detailed choices and arrangements regarding the painting elements, layout, and the structure of the image, so that his personal will has been exercised through the image at issue. Now the AI model is similar to the author's painting brush or camera, merely a creative tool by the human user. Application of law is to use a series of scientific methods to interpret the law, even at times to fill the gap in the law based on certain principles and methodology. In applying the law to novel challenging cases, we often have to do a balance of interests. Generally speaking, I would firstly consider the interests of both parties, including those of the corresponding interest groups both parties belong to. Then consider the value choice made by the legislators when the law was made, and lastly, consider public interest in a society. In this case, firstly, we identify with the value choice made by the legislators. The very purpose of Chinese copyright law is to encourage creation and dissemination. Under certain circumstances, the status of authorial work should be given to contents generated through AI, with the goal to incentivize people to use this brand new tool to create, which corresponds to the inherent purpose of copyright law. When judging this case, we would also consider the potential implications on the emerging industries. The judgment encourages users to utilize the AI tool to create, and only when the interests of the users are adequately protected, more people would be willing to use the AI software. The AI developer owner would have more profitable earnings, and only when the developer owner has more earnings, they would increase the investment to the technology. And eventually, the advancement of technology would attract more users, thus entering a virtuous circle of use, benefit, investment. Lastly, we would also consider the public interest. Under current technical conditions, it would be relatively difficult to differentiate AI-generated contents from non-AI ones. Thus, if we discriminate between these 2 categories, granting protection only to those painted with conventional tools by human, but not to those painted with AI tools, we are actually sending a negative message to conceal the AI tool and hide the very creative method. This would breach the public interest to disclosure. So having made these introductions, I have this question for both Professors Cui and Wang, and maybe Professor Murgis too. I'm not entirely sure how familiar you are with the Chinese opinion, but you're welcome to chime in. So would you please, professors, would you please share some of your own assessment of the conclusion and reasoning of this case? Do you think it's in light of the authorship doctrine in China?
Okay. Probably Professor Wan Chen will do first. I don't know. What's the proper order?
I think
I need to
according
say
to
first.
the gender, you go first.
Okay.
Okay, let's stick
Thank
to
you.
the gender.
Okay, I briefly make my own comments on this kind of decision. First, it's about the factual issue, whether the specific or the dispute work here is original enough under the Chinese copyright law. For me, I think if you read the decision, some key elements is not factors is not disclosed very clearly here. For example, why they choose the random seed and why they change the random seed later on. So for me, it's a little bit difficult to evaluate whether the picture really embed the authors or the users' original contribution. So I don't want to say too much on the factor issue. Here, I'm focused on the legal reasoning. In general, I agree with the court. It's come out with a good approach in dealing with this kind of AI generative work. So I tell guys why. Actually, under the Chinese copyright law, to be an author, you should make some kind of intellectual contribution in the creation process. What it means creation, I think the Article 3 of the implementing regulation of our Chinese copyright law say creation mentioned in this law means intellectual activities from which literal, artistic, and scientific works directly result. So here, the key is what it means direct result, right? Desired result in this kind of work. Look at this kind of case. At the first round, the plaintiff only input this kind of 50, the promise, and the prompts which have 50 English words. And probably we can say the plaintiff directly result, this kind of input directly result in a literal work, right? This kind of text having 50 English words, maybe it's original, so it could be copyright as a literal work. In this respect, I think Chinese law standard for originality is pretty low. As I understand in the past, in many cases, a very short sentence, sometimes just have 7 to 8 Chinese words could be accepted as a copyrightable literal work. For example, as an advertisement slogan about, I think the tobacco, say, 一品还山，云淡风轻. And Chinese word just has several, I translate into English, maybe just 5 to 6 words. So many courts say this kind of short sentence could be copyrighted. So in theory, if you come up with a very complicated prompts, like the problem, not this one, maybe in another case, you could claim possibly it as a literal work. When you come up with a literal work, whether that means you have made a contribution to the resultant picture generated by AI, I think that's completely different. In theory, sometimes you can describe a picture in a literal work, right, or through a computer program. For example, a lot of computer games, they instruct the computer to generate a lot of beautiful picture on the screen, right? But they never draw the screen and the picture directly. You only write the code, and then the code instruct the computer to draw this kind of picture. So that's under the Chinese copyright law, the picture shown on the screen, even it's generated by the computer, it should be viewed as a painting or picture created by the program developer. That's no dispute. So it's possible for you to describe a picture in computer program or in a literal work. Another example is, for example, a digital file of a picture. Actually, from the computer perspective, it's also a set of computer readable codes, right? Consists of the digit of 0 and 1. So it looks like a literal work. So because it describe the picture very accurately, cover almost every pixel, right? So it's also like a literal text describing a picture. So even in that kind of extreme situation, when you finish this kind of literal work or computer code, you also can claim you have make a original contribution to the picture. I think that's pretty clear. But in terms of the AI background, whether this kind of regular prompts like this one in the Li versus Liu case, I think that most of the keywords are very general, right? From which a reader could not get an idea what the picture really looks like, right? For example, a Japanese idol or beautiful face. I think it's very general. So it's, if you look at the Article 3 of the Chinese law, probably we can agree. We will agree. It's not the user is not a direct author of the picture because they make almost no original contribution to the expressive elements in this picture. The picture was generated automatically by the AI system. So I think I agree with the court on this first round or the single round is not the author does not make an original contribution, and that's about what it means directly result means under the Chinese law. And the second issue, because here the user not only input the initial set of prompts, right? They keep revising or changing the picture. So whether this kind of further revision could satisfy the requirement for originality, I think probably the answer is yes, because under the Chinese copyright law, the originality standard is very, although it's not very clear, but in general, most of the scholar or the judge agree the copyright law's requirement is very low, right? It only requires the creation to embed your personal choice and the minimum requirement of creativity. I think they're very similar to that in the United States. Only in some exceptional situation, we have a serious dispute on whether a work is original or not. For example, in the past, we have a serious dispute on whether the recordings of a sports game should satisfy the originality requirement under Chinese law. I think including here, Professor Wang have a pretty high standard for this one. And except this kind of extreme case, in most situation, we believe the originality is requirement pretty low. So here, if the users has revised the AI generated picture through many rounds, I think that's could possibly embed the author's personal choice, and that's my conclusion. Okay, because probably we are run out of time. I will add my further comments later on.
Okay.
Okay.
Yeah. Thank you, Professor Cui. Professor Wang, we'll hear you.
Okay. Just as Professor Cui mentioned, in Chinese copyright law, the concept of authorship is closely tied up with the act of creating work. And the copyright law of China clearly defines the human author as, quote, the natural person who creates a work, unquote. In addition, the regulation on the implementation of the copyright law of China defines the act of creation as, quote, intellectual activities that directly produce literal, artistic, and scientific works. I believe they are very straightforward provisions. To qualify as the author, you must create work. And to create work, you have to be the one who directly produces the work. So the key phrase here is directly produce. I think that it implies that a natural person exercises the individual choice and judgment based on the free will to decide the substance of the content. The person might complete the work with some tools, such as the painting brush, as Dr. Yuan mentioned, the camera, or Photoshop. But these tools will not be involved in making decision about the substance of the content. They merely serve as the passive instruments, which enables the person to implement the creative decision. For instance, there were a lot of word processing programs like Microsoft Word or the WordPerfect. They are merely the passive tools for people to create literal work. It does not matter what kind of word processing program a writer is using. Could be Microsoft Word, could be WordPerfect, could be the Chinese program named Kingsoft WPS. The same choices of the writer to pick words and to put them together in certain ways consistently end up with the same piece of writing every time on each time. In a sharp contrast, a user may operate the operative AI to generate content. However, the generative AI is not just a mere passive tool for people to create, just like Microsoft Word or Photoshop. The user's input, including, for instance, the text prompts or numerical values or other kind of inputs, can only influence the style of theme, the style and the theme of the resulting content generated by AI, without decisively determining the substance of it. For instance, if the text prompt is to draw a picture of a young girl, the AI system won't just produce an image of old man, but what does the girl exactly look like? No matter how detailed the text prompts might be, they couldn't decide exactly the composition of the image of the girl. If the exactly the same complex, detailed, specific, or imaginative text prompts are given to several AI systems at the same time, they will yield vastly diverse outcomes, some of which will be out of the expectation of the user. I would like to show you an experiment I did. It's a very interesting experiment. I selected an English poem which describes the beautiful scene of sunset. And I fed this English poem as text prompts to 2 AI systems. And let's see the outcomes. This is image from the first AI system, DALL-E. And this is image from the second AI system, Midjourney. And it's very obvious that the 2 images are totally different, though the 2 systems generates the images based on the same text prompts. Why it happens? The reason is very simple. The AI system itself is involved in the decision-making process of the resulting image. The AI system is not just a passive tool for people to create. The user's input cannot decide the output of AI, which is determined autonomously based on the AI's unique algorithm and data training. This is why we can't equate the user's act of supplying text prompts and other input to AI with the act of creation as defined in the Chinese copyright law. At this point, I think the judgment is seriously flawed because it confuses the generative AI system with the traditional tools of creation. The court treats them alike, but actually they are fundamentally different. Regarding the specific users' input to AI to generate images at issue in the judgment by the Beijing Internet Court. A friend of mine also conducted a fascinating experiment on 3 computers. My friend ran the same AI program, Stable Diffusion, with precisely the same text prompts, numerical values, and underlying model package as described in the judgment. And let's see the outcome, which is quite astonishing. There are 4 images generated by Stable Diffusion on the first computer, the 4 images generated on the second computer, and the 4 images generated on the third computer. Please keep in mind, there's only one AI system, Stable Diffusion, and the text prompts, the numerical values, the underlying model package on 3 computers are all the same. How come? The 3 computers generated totally different 3 sets of images. That is precisely because the AI system itself is involved in the decision-making progress. The AI itself decides the exact composition of the image combined with the computer's hardware. The user's input can't decide the outcome. It can only influence the theme and the style to set the tone for the image. But the user cannot even expect what he's going to have from the AI system. So that is what I want to say about the authorship in Chinese copyright law. In addition, I also want to stress that the reasoning in this judgment is also serious flaw. I would like to show you a paragraph from judgment. I'm sorry, it's a little bit long, so I just make a conclusion of the meaning of this paragraph. The judgment says that if a commissioning party hired an artist to finish a work, the work is the commissioned party, then the artist's work should be regarded the work of the commissioned party. That is the artist. The commissioning party should not be regarded as the author of the resulting painting, because it is the artist who is hired by the commissioning party to finish the work based his free will, and he exercised his judgment and choice to finish the painting. Then the court clearly acknowledges that a commissioning party is very similar to a user of generated AI, and the commissioned party, the artist, is also very similar to the generative AI, and the AI generated content is very similar to the commissioned work. Then it comes to the question, why the judgment treats the user of AI giving the text prompts and the commissioning party who gives requirements to the artist so differently. The judgment explains that this is because the commissioned party has a free will and makes individual choices, while the AI does not have free will. I don't think this argument can hold up. I want to do a so-called thought experiment. The first step is to approach an art teacher and tell him that he has good luck. He can get any painting he desires, free of charge, provided that he meets 2 conditions. The first condition is that the painting must be highly original and creative, not similar to any existing painting in the world. The second condition is that he must describe the painting very in a very detailed way, as detailed and as specific as possible. And the description must include all the elements he wants to have in the picture and all the elements he does not want to have in the picture. And then we ask the art teacher to write down his instructions on a piece of paper. We don't tell the art teacher who will receive the description and who will draw the painting. Then we go to the second step. Once the teacher has written down all the requirements in the note, we flip a coin. We just flip a coin to decide who we are going to give the note to. Heads up, we will give the note to an artist, and the artist will finish the painting in accordance with the judgment. In this scenario, the painting is the painter's work, not the art teacher's work, because the painter has free will, and the painter exercised his personal choice and judgment in finishing the painting. Tails up, we will give the note to a generative AI, and the AI will complete the work to generate a painting. In this case, in accordance with the judgment, then the painting is the teacher's work because the generative AI does not have free will. So the teacher can claim authorship and copyright over the AI-generated painting. Now let's keep in mind that the only thing the art teacher has done is writing down the complex and detailed description of the designed painting. This is the only thing he has done. Then, in accordance with the judgment, whether or not the art teacher can be acknowledged as the author of the result painting hinges solely on the twist of luck or the wish of God. If the luck is on the art teacher's side, when we flip the coin, tails up, then the note will be given to a generative AI as text prompt. Then the art teacher will be regarded as the author of the result painting. If the teacher has very bad luck, heads up, then the note will be given to the artist. Then the art teacher cannot claim copyright over the result painting. I think this result is totally against the law. It's totally a law. It's totally out of the logic. So I don't think the reasoning is a sound one.
Thank you very much, Professor Wang and Professor Cui. That's fascinating, actually. A lot of issues you guys covered. But if I may just try to summarize the major difference between Professor Wang and Professor Cui in one sentence, it seems that you have a different view regarding the type of control the so-called author has over the final output. And I appreciate that, Professor, both of you cited Article Section 3 of the Implementing Rules of Chinese Copyright Law, which basically gives a definition to creation. The author has to directly produce, which sounds like to me implying there's a direct causation, like what the author does have to directly cause the final output. So I don't know if my understanding is off the track, but it seems to me that's the major difference between you two.
Yeah, actually, I think I can make some kind of replies, but probably Professor Merges will
Yes.
make his comment first, and then I will reply.
Because a lot of
Okay.
the issues you guys covered when we, it will be maybe further clarified when we talk about US copyright law too, because I see a lot of overlaps here. So
Okay.
let me turn to Professor Murgis for now. So Professor Murgis, maybe you could briefly introduce some of the recent US copyright decisions in this field, as well as the DC District Court judgment in the Thaler versus Perlmutter, regarding the same authorship issue only. You're muted.
I got it. Yeah.
Thank you.
Okay. Yeah, that introduction was terrific, and I think the Beijing Internet Court, they should be thanked, I think, not just in China, but around the world, because that is a very clear opinion. A lot of thought went into it. And I think it sets the issues up and describes them really well, neutrally. In terms of the analysis, I think she also states her reasoning very clearly. And I think it's a nice paradigm for the way to approach these issues for any judge anywhere. I'll talk about the actual result, the outcome that Professor Shui and Professor Wang have been talking about. In just a minute, that's the comparative part. I think I wanted to start just by talking briefly about US law. You asked me to mainly address that. I think the most important expression of US law right now is in the Copyright Office regulations, because the reported case from the district court in Washington presented fairly narrow facts and probably not a typical scenario. It was somebody who just was clearly looking for a test case or a kind of statement, sort of an event. And I think he probably predicted that he would lose. But anyway, that was just an attempt to just sort of outright get a declaration that AI-produced works can be copyrighted. And the court wasn't going to go that far at this point. I think no court around the world has gone close to that result. If you look at China and the US, both have decided, without stating it really, that we're not simply going to look at the output and say, we don't care how this work was created. Is this work in some, universal sense original or not? We're not doing that, right? So the first point of concordance between US and China is that both are asking the antecedent question, how was this work created? And, I point that out because I think it's the right approach, but there is a school of thought which says, why are we asking this question if the goal of copyright is simply to get the maximum number of creative works out in the world? You could make an argument that the development path, the background, the cause of the image or work doesn't matter, right? So we have decided that, let's say, call that view strict output neutrality, right? We don't care where it came from, just the output. I think we have decided to reject that approach. That's a point of overlap. So the US Copyright Office has said they take a position that I interpret to be closer to Professor Wang, which is to say, their test is if the traditional elements of authorship are produced by the machine, then you cannot register it. There is no author in the sense that the US copyright statute requires. Okay? So what the US test and approach does is to focus on what it calls how the work is produced, how it is produced, right? And it's taking the approach that if some of the attributes of authorship are caused by the machine, then you can't get a copyright on it. So the first point is that it does, I think, try to distinguish between a simple tool and the more complex, sophisticated tool, the Centaur tool, Professor Howe calls it, I think, accurately. So the differentiation going on, they're trying to say you may use a tool, but if the traditional elements of authorship are attributable to the human, then it's copyrightable. So people will point out that, the choice of the brush for calligraphy will affect the image, and I don't just mean the size. I mean, a particular brush will leave just a very, an image that maybe only that brush precisely could leave. But the traditional elements of authorship, what character are you doing and what's the general shape, those are the human. So they're trying to recognize that we have a new type of tool, a type of tool that is not just, let's call it a slave to the human using the tool. A brush is a slave, it does what I want it to, kind of thing. That this tool is in a different category. And the way the registration regulation works is it asks the very general question: did this intelligent tool help produce the work by producing some of the traditional elements of authorship? So it is trying to differentiate between different types of tools, but it comes down on the side that if some traditional element of authorship, even just part of it, is produced by the machine, then the Copyright Office says that infects, you might say, it spoils the totality of the work. It spoils it because some of the authorship elements are not produced by the human. So it takes a fairly strict view in the sense that it doesn't weigh the contribution. It just says if the machine produced the traditional elements of authorship, it's no good. So it's a little more, I would say, you could say anti-AI or suspicious of AI, or on the other side, more humanistic, more let's preserve the special role of the human author kind of approach. You could categorize it that way. But I get back to my first point, which is I think both the Chinese cases and the US authorities, they're wrestling with the same problem. And Guobin brought it up, Professor Shui brought it up, which is we are talking about causation. We're talking about what is the law going to do in a situation where multiple causes combine to produce an event, an outcome, right? Now, if it's an accident, if we're talking about tort law, if we're talking about obligations where somebody has caused an accident, right? There we are used to this analysis. This is traditional. This is understood. And depending on the rule we adopt, we weigh with different weights, but we do consider all of the causes that went into an accident. In the easiest case, we look at what did the driver do, and then did the victim do anything to make the accident more likely? Did the victim contribute to the accident? Did they help cause it, right? So there we try to tease out the different causative elements, and we say, let's ask a policy question. Let's say, who is the most important cause? Who is the causer that we have solicitude for, that we care about, that we want to focus on, right? So we call that the person who started that causal chain the proximate cause, the important cause, the cause where liability is going to lie, right? So we make a determination about proximate means close, the close cause, the cause that's most direct. And we make a judgment about that, depending on who we think should bear liability. So here, in this case, the two causes are combining not to produce an accident, but to produce a creative work, right? So here we have mutual causation for something good, a benefit, a creative work. That's good, you know? So, but we have to ask the same question. We have to say, what are the different causal elements and how should we weigh them? How should we balance them, right? Okay. Now, I think that the humanistic view has a very, you might say, comprehensive and strict view of causation, that the human actor in the situation for copyright must be definitely the proximate cause and almost really the only cause, or definitely the primary cause of the creative work, right? So we get the excellent hypotheticals from Professor Wong pointing out that general direction or instruction begins a causal chain, whether it's instructing a commissioned artist, a human, or whether it's instructing AI, right? Now, I think his examples are good because it shows in the one case, on his reading, the human commissioned work would not be attributable to the commissioner, right? The person commissioning the work, that wouldn't be right. But in the AI case, he reads the Lee opinion as saying that the commissioning party would be the author, right? Now, I think here we're on it's a more fine-grained question about the degree of causation, seems to me. But I think one response to that hypothetical, and this is a response that would constitute a criticism or critique of the US regulations, right? One response to it, I think, you know, it could be described as you're talking about very general description and instruction at a high level. But what Professor Cui was talking about and what the opinion talks about is trying to constrain the discretion of the tool, trying to limit the causal contribution of the tool as much as possible through this series of prompts, through the refinement of the prompts, right? So I think we're getting closer in a way. I think the debate between Professor Cui and Professor Wong is instructive. I think it calls attention to a major problem in the US regulations for me, because the US regulations do not see the decision or choice. It doesn't see the judgment or control of the final work as including, you know, the intellectual element, the plan or the idea, right? It talks about, you know, how is the creative work produced, but it seems to be more focused on physical or mechanical production and not as much on the decisions that go into it. At least that's my reading, right? So here's what I'm trying to say. I think we could agree that the real question might be, you know, whether variation, even in the case of a very long prompt, whether variation in the output disqualifies the work because some of the decisions are being made by the machine, okay? We could say that, but I think what Professor Cui is saying and what the US law probably should reconsider and think about is, you know, maybe some variants, some decisions or choices can be made by the machine and still we can retain the idea of a human author if most of the decisions, if the majority of the decisions, if the bulk of the decisions are made by the human, right? So mere variability in the output could be tolerated if we decide that at a high enough threshold, the human is creating the work. They're the proximate cause of the work, right? And of course, the example that people will cite is photography. the photography cases are really very similar to the analysis I'm talking about, because there, the execution, the production is a machine, it's a camera. Okay. But what makes photos copyrightable is not just pointing and shooting, which involves very little decision making, but obviously lighting, shading, perspective, and then later filters and post-production, manipulation of the image. So you see, my point is that the photography cases already admit some variation on the part of a machine, but we can still have a human author. So I think that's a route we may need to go. My point though is I think the US regulations are going to hit a dead end. They're going to cause problems. And I imagine either a court, Congress, or maybe the Copyright Office will come back to them. I don't think this is the last word. I don't think it holds up very well.
Thank you, Professor Mudges. There are a million terrific points all three of you made. So I try to take them down, but let me just, pick some of the major ones. And it seems to me, okay, so regarding the camera part, Professor Mudges, I think you really have a point there, but also I think Professor, if you emphasize, the photographer has the freedom to make his or her original choices there. But I think Professor Wang's point is equally valid here, because camera could be a rather passive tool compared with generative AI. I think the major difference between all three of you, if I can try to summarize, is still regarding the kind of control the human author has the final over the final output. So I think it's particularly tricky question, and to me really could be a question that reasonable people defer at this point, particularly in light of the lack of complete clarity of authorship doctrine in both countries. I mean, compared with with China, US has several centuries of authorship or copyright law. It has had many fascinating authorship cases, but still, maybe unlike the inventorship doctrine in patent law, which US had 2 centuries of, interference proceedings. So that part of law is particularly clear, but authorship doesn't. But if I can just borrow the causation framework Professor Mudges used, because I find it particularly useful, it seems that this extra space for machine creativity by Gen AI could work as some unexpected elements in a causation link. So this would be the game changer here. But also, there are some other US copyright law scholars, for example, Professor Jim Ginsburg and Luke, I think the Luke Joy, I pronounce it right. They had a paper in 2019 called Authors and Machines. So in that paper, Professor Ginsburg unpacked the authorship doctrine in US patent law, finding that consisting of 2 major steps. The first is conception, meaning this detailed creative plan. And the second would be execution of this mental plan. The tricky part is that traditionally a human author has to fulfill both steps. But for the generative AI situation, compared with the camera situation, is the AI arguably participated intensely in the execution step. I mean, maybe some of the conception step as well. If you think of the image in the Lee versus Liu, or even the space theater, the Theater de Opera spatial in the US. So it just looks to me that this might be for some time, maybe reasonable people would not agree with each other completely. I don't know. What do you guys think of it, Professor Cui? Yeah.
Okay. Thank you. Actually, I fully agree with Professor Mudges, and about the theory of degree of causation. And now I try to apply this theory and to make a reply to Professor Wan's argument or comments. I think actually, if in this case is the dispute work is just the outcome of the single around input and output, I think I would be fully agree with Professor Wan's comments. That's true. If you just come up with a set of prompts, and even the prompt is pretty complicated, right? In this case, about 50 words, and the negative prompts about 3 English words. I think even you come up with a prompt has 1,000 or 2,000. That does not make a large difference. That's true. When you create this kind of prompts, you don't know what the AI will generate. So you have no clear idea what's the structure or the contour or extract element of the picture. So you definitely have no control. So only, as I mentioned previously, only in very exceptional situation, for example, you come out with a computer code, you dictate the outcome of the screen printing. In that kind of scenario, you can say your orders, your program codes have dictated the output. But in terms of AI generated works, in most time, the prompts just give including some very general terms. So does not mean you know or predict or define the expression element. So you have no control. So if you give this kind of orders or prompts to AI, just like as Professor Wan mentioned, an independent contractor artist or combination party or our employers, you give this kind of a prompt to an order and to an artist or to an AI, I think the result is the same, right? Legally, the outcome should be the work of the artist or the AI. That's completely fine. But here, I think what we are arguing is completely different, because we not only had the author, the user has made this kind of single round input and output. Actually, the users, after they input specific prompts, and then the user selects one of the picture from hundreds or thousands of candidates, right? I think the same set of prompts could generate probably hundreds or thousands of pictures. So the system allows the user to pick one of them, right? So this kind of selection, select one because you probably believe the particular one satisfies your need, right? So this kind of selection embeds some kind of personality, although this kind of selection itself, just in this kind of single round, is not original enough. But according under the copyright law, you can make a lot of this kind of selection one by one and combine them together. Even according to the US Copyright Office approach, this kind of combination of selected pictures itself could be a combination of original works, right? So if you do a lot of this kind of selection, you could make a original contribution. So the users select one picture. I think this can embed some kind of personality, even it's not the original enough. And then after they having selected this kind of specific picture, the users obtain, I think start to obtain a very clear idea what's the potential picture or potential content of the work, right? Because now a specific picture are presented before your eyes, rather than a set of very abstract prompts. So you know the specific target now you are working on. And then in theory, I think now the AI system could be combined with numerous plug-in tools. If you, with this kind of combination, AI and all kinds of plug-in tools, and then the user could revise almost every expressive element in the selected picture in a very personal way. For example, last time when I was invited as a commentator for the real-time online broadcaster of the judicial hearing of this case, at that time, the Tencent expert showed us how to use an AI tool once you select a picture, and then how to add a boat, add a tree or moonlight in a specific area, in a selected picture, and how to change the color of the select area or element, how to change the subject posture in a picture, something like that. So once you have a specific picture in front of your eyes, right, and then you could divide the picture into 100 or 1,000 of small areas or small windows, and then the AI could follow your order to revise every window or every small area, right? Of course, you don't need to brush the area with your hand, right? You just the AI system could present possible candidates in the small area, and then you could just pick one of them. You still have a lot of choice, right? So you can imagine the whole screen could be divided into 100 or 1,000 small windows. In each window, you have a lot of this kind of choice, and then combine all together, you get a very, I think, a personal result. So this kind of personal result, I think that's could be the original work of the author, because sometimes you don't need to be a contributor of every element of the work. For example, a selected work of Mark Twain, right, or selected work of Karl Marx. Even you don't author the Karl Marx work, but you have been limited by the overall work of the author, but the selection itself is original enough. The same thing happened to once you select a specific picture, and then you have a much clearer idea of what you are doing, and then your choice are narrowed to a lot of small windows, right? Combine them together. I think this kind of revision is endless, right? To determine which area, which elements to revise, and how to revise, and which output should be selected. This kind of work is intellectual activity, inevitably embedded the user's artistic judgment. So this kind of fruit should be protected by the copyright, just like we have protect the author's work when creating a combination of work, something like that, right? That's my argument why actually we have enough control over the outcome of this kind of AI generated picture. It's not, if you each time you simply input a new types of prompts, and then you don't work on a specific picture, I think what Professor Wan Qian's talking about, you probably perfectly fine, right? Right, because each time you don't know what's the result. So that's my argument. And then I'm happy to know Professor Wan mentioned the independent contract artist, or the teacher and the student, or teacher and artist scenario. I think that's this argument is not convincing. Why? Because sometimes the teacher, if the teacher gives some instruction to artists, the instruction usually is very general, right? And then artist come up, execute the instruction. And in this kind of process, that's no very detailed interaction, right? In AI system, it's very common. When you give an instruction, the AI come out with a result, and then you make a choice, right? The AI give you hundreds of thousands of choices. You make a choice, and then you determine whether to revise part of that, and then AI give you further choice. So if you wish, you could almost dictate every element of this kind of picture. So it's completely different from the interaction between a teacher and a student, or teacher and artist. That's my understanding. Okay, thank you.
If I could quickly jump in, it's very factual sensitive, actually, very factual dependent. I mean, even in a situation Professor Wang pointed out, I think it's a very critical, fascinating example there. You can't really discriminate because it's related to the copyright neutrality. But there were authorship cases in U.S. copyright law, like the Titanic ship case, which the New York District Court held that if the photographer give specific enough instructions to his assistant who dived into the very bottom of the ocean to take the picture of excuse me, of the ship, then the photographer who never actually executed those instructions could be found as the author. So, Professor Ginsberg talked about this so-called principal agent doctrine in U.S. copyright law. So I think it might be helpful to put a number. I know we can't really be entirely precise, but if you all three of you and put a number, like what's the quantity, what's the ratio of human control over this creative process, as well as the final product. You would think he's the author, be it, it's a human assistant or AI. I think it might be helpful. Professor Cui, so what's your number? Roughly. You're muted.
I think that's very difficult to put a quantum threshold for this kind of requirement.
Yeah.
Probably, if I think the selection is adequate enough and embedded a personal choice, maybe I think 10 to 15 or
But
20.
even like 10, yeah, but like you said, even 10% could have personal original
Yeah.
selection.
For example,
But this is what the US Copyright Office said. You have to really disclaim that more than de minimis contribution by the AI.
The US standard I would interpret as being less than 5%. Certainly less than 10%. I don't know if you agree, Professor Wong, but it's a small de minimis, the Latin is quite small, very small. So now,
Okay.
no, go ahead.
Please go ahead first. Please go ahead.
I was going to say, first of all, I would say whatever number you come up with is just, certainly not binding for all time. But to me, I'm kind of drawn to 51% human. I'm kind of drawn to just a little more of a human cause, maybe not by much, but just a little more. That somehow that number right now sounds like the right one.
Okay. I would like to respond to Professor Cui's comment. I understand Professor Cui's theory of so-called multiple round generation of content very well. Because I read his article, I heard his comment, so I did an experiment. Let me show you that. Suppose that Professor Cui and I are using generative AI to produce images, and Professor Cui is using Stable Diffusion, and I'm using Midjourney. It happens that both of us are giving the same text prompts to the AI systems. The text prompt is Chinese girl style. Of course, it's very generic. And let's see what comes. This is the image generated by Stable Diffusion. This is image generated by Midjourney. Of course, they are remarkably different. And both Professor Cui and I think that they are not the copyrightable work authored by the users, because the text prompt is very generic. The text prompt cannot decide the substance of the image. Then neither of us is satisfied with images. So we just continue to input more text prompts. On the second round, it happens that both of us gave the same text prompt again. Chinese style girl glasses. This is the example described in Professor Cui's article. Let's put a pair of glasses on the girl in the image. And this is the image revised based on the pre-existing image generated by Stable Diffusion. And this is the new image generated by Midjourney. Then neither of us is satisfied with the second images. So we continue. It happens again that, oh, please take a look closely at the image generated by the Stable Diffusion. There's third arm. It's very terrifying. I believe it will be out of the expectation Professor Cui. Now, on the third round, we continue to input the text prompts. I used the exact phrase described in Professor Cui's article. That is, reduce the height of the glasses frame to 2/3 of their original size. And the spooky thing happens. Neither of the two AI systems understands that text prompts. So as a result, in neither images, the height of the glasses frames is reduced a little bit. If you take a close look at the glasses in the two images, you'll find that it means what? I remember the US Copyright Office says that generative AI is not like human being. It can't really understand the instructions from the user. It's working based on its own model, based on its algorithm and data training. So on the third stop, the experiment has to, on the third round, the experiment has to stop because the generative AI systems can't understand the text prompts. And there's another point. Please keep in mind that in the three-round production of the image generation by AI systems, both Professor Cui and I gave the exact same text prompts to the different AIs. If we use threes in the judgment by the Beijing Internet Court, that is intellectual input. How come the same intellectual input results to totally different, dramatically different images? Because a user does not have real control of the outcome produced by the AI. And I think that Professor Merger's comment is very thought-provoking. I really love it. Professor Mergers talked about some variations made by AI. That is what I heard. But I think the AI does not only contribute some variations to the final outcome, it contributes to the most part of it. Let's go back to that experiment did by my friend in accordance with the descriptions in the judgment by the Beijing Internet Court. I want to tell Professor Mergers that we don't reach that outcome by a few words. The total number of the text prompts, including the positive prompts and the negative prompts, are more than 700 words, quite a lot. However, with the same complex, with the same detailed, specific, or even imaginative text prompts, using the same AI system on 3 computers of different hardware settings, we have totally different images. How comes? The reason is very simple. The AI does not only contribute a little bit, it decides the major part of the image it generates. All the person's input can only influence the style, the theme, or some variations. So if Professor Mergers is right about the 5% theory, I think what the AI contributes to the outcome is much, much, much more than 5%. So let's turn to the third example. Professor Cui mentioned the scenario of art teacher instructing students to draw a painting. I want to use that example as well. Consider an art school teacher instructing 30 students in the classroom to draw a painting. The art teacher gave students not only generic, not only general requirements as Professor Cui supposes. No. The art teacher gives very specific, very complicated, very detailed, or even very imaginative instructions requiring all the elements that must be included in the painting, and certain elements that must be excluded from the painting. In the end, 30 students created paintings, and the art teacher is not satisfied. Is not satisfied with any of the 30 paintings. So he gave a new set of complicated, detailed, specific, and imaginative instructions to modify all the 30 paintings. Again, 30 students finished 30 paintings, but the art teacher is not satisfied. It does this over and over and over again for 10 times. In the end, the art teacher is very satisfied with the final 30 paintings finished by the students. Should we allow the art teacher to claim authorship and copyright over the 30 finished paintings by 30 students simply because he gives very detailed, specific, complicated, imaginative instructions, old instructions, new instructions over and over again? Of course not. His instructions as such might constitute literal works. There's no denying of that. But we are talking about the legal status of his instructions in relation to the finished paintings by 30 students. No matter how detailed, how specific, how complicated, how imaginative these instructions might be, one round or multi-rounds, they are only unprotected ideas in relation to the finished 30 paintings. The art teacher lacks the sufficient control over the finished paintings. I think the same situation.
I just want to clarify on that point because it's very important, Professor Wang, is that, but you said, but because these instructions were so specific and complete, so, but your point is even if it achieved maybe 90%, 95%, it can't make the teacher the author, right?
It's impossible. It's impossible for the art teacher to contribute 19% of the composition of any finished paintings by 30 students. It's just impossible. No matter how detailed, specific the instructions might be, the teacher's contribution can't reach the level of 90%.
Right, but both in the US and in UK, in Britain, there were plenty of earlier cases, like in the last century, that about this principal agent doctrine. Professor Ginsburg pointed out that in those cases, if the principal give extremely specific instructions and the agent just loyally exercised instructions, then the principal would be considered the author. And also in the Titanic ship case, that was a recent case,
Okay,
right?
2 points. The first point, there might be an agreement between the principal and the agent. The license, the agreement.
Can you agree on the authorship doctrine on status? You can agree on the ownership, but authorship status.
No, I'm sorry. I think there might be agreement, the express agreement or implied agreement between the principal and agent. In that case, it's not the authorship factor that plays out. It's agreement between the two parties that plays out. Second point, some old cases in 19th centuries might be the result of the so-called sweat of a brow theory. They are outdated.
Right, okay. Yeah, it just and with those were just fascinating. I could talk forever with you guys on this, but I see we only have like 20 minutes. I saw a lot of questions too, but I think it would be fair for me to, if I have to draw a conclusion on this at this point, is it seems that reasonable people might really differ on whether, you know, what kind of authorial control, what is the quality and the quantity of the human contribution, the control over the final product to make him or her the author. So like Professor Merges gave a 51%, 49%. Professor Cui gave like maybe 10 to 20%, and Professor Wang didn't give a number, but I have the impression that for you, it should be really very high. So, but now I think this is why we have to enter the next phase, because if for some time reasonable, top renowned professors as you and policymakers, reasonable judges might differ, then maybe
Sorry, I just want to make a very
Yeah.
quick comment on
Sure,
Professor Wang's
yeah.
experiments. Very important. It's
Okay.
actually about the function of the technology. I'm very happy to see the example raised by Professor Wang. Actually, in his case, whether he could manipulate a specific element in a picture accurately, that depends on the technology. If you have enough this kind of add-in tools, and then could allow you to fix the initial picture and then only change a small part of that one. So you need this kind of tools, and also you need to follow the grammar. For example, if we want to change the size of glasses, you need to put a bracket after the keywords, and then in the bracket you input the keywords, and then can understand perfectly by the system. If you don't have this kind of technology or add-on tools, and then the result would be very bad. So that's for me, it's not surprising to see the result. So I think technology provides all this kind of possibility. Okay.
Okay, but I have to tell you that this experiment is not only done by me. I asked a lot of my friends. Some of them are very skillful in using Stable Diffusion to do the same experiment. And no matter how they try, no matter what kind of text prompts they try to input the Stable Diffusion, as Professor Cui describes, to change the grammar, they can't reduce the height of glasses. But that is not so important, I agree. My point is, if we have two AI systems, we give exactly the same input. It does not matter one round or multiple rounds, we will get remarkably different images. That shows that the user's input cannot decide the substance of the image as a result of AS generation. And I think that Professor Cui expect that from the second round of content generation, AI suddenly becomes something like Photoshop. However, I don't think so. A user is not a magician. The user does not have a wand to transform the generative AI into Photoshop. They are different. If the AI is a black box on the first round, it can't mysteriously turn into a transparent box from the second round onwards. The AI remains the same black box from the beginning to the end. And Professor Cui talks about the work of compilation. However, the work of compilation is quite different from the situation we're talking about in the field of AI. If I have 10,000 pictures generated by AI on my table, and I select 100 of them, I compile them and publish that book, I can claim copyright over the work of a compilation because I exercise the personal judgment in selecting, coordinating, and arranging the different pictures. But the situation is dramatically different for the AI's generation. On each step, the user might give specific text prompt to AI, but the user can't just expect what really comes, even if it's a very specific text prompt, for example, to put a pair of glasses on the girl in the image. What kind of glasses? What style of glasses? Even if we make it more specific, for example, a classic style or a modern style glasses, we never know what comes out.
Great. So very nice, vigorous debate. But I think at this point, it would be fair for me to draw a little conclusion that at least in many generative AI cases, compared with the more passive AI cases, we actually in the theater, the opera, the case, the Corporate Office of the United States, it just differentiate between two kinds of AI too, and just only talk. But in any event, my point is, at this point, it seems that at least for some of us, the human contribution in a general AI creative process are not sufficient to amount to to fulfill the requirement. And if I may again cite Professor Ginsburg's name for these kind of works, they had their the work has a quotation mark because they have the appearance of original works, but actually you can find a human author in a loop for the reason we just talked about. How do we deal with these authorless works? So I think for the next 15 minutes or so, we need to dive a little beyond the doctrinal level. And also, I think this is why generative AI is fascinating to me personally, because it would force me to go back and revisit some of the roots of the IP system. So I'm going to direct this question to Professor Murgis first, because that's what I will do. Professor Murgis. So how would you advise?
Now, see, there's a decision, right? Now, that's a choice.
Yes,
okay.
Yes, as the moderator, yes.
Yeah,
I'm going to
the moderator's exercising choice.
Yeah.
Well, sure. So first of all, I wanted to say that I think there can be a false precision in the percentage approach, which of course I borrowed from comparative negligence, where in tort law, if you are a 51% cause of the accident, then you will bear liability, either all of it or at least 50% of it, right? So anyway, but I think the examples point out that there's always a factual question before you get to the answer if you take the percentage approach. And somebody asked, what about qualitative elements? In other words, we could differ as to what percentage of the choices are being made by the machine, right? It's hard to quantify the number of creative choices that go into the work. If we could somehow, if we could agree on every decision point, but of course, it's very hard to model creativity like that. You are eliminating possibilities as you go, but it's not always clear you're making a choice. Sometimes the next act is constrained by the last one. Anyway, I think the point is that it's a good thought experiment, but wow, is it going to be hard to apply? But of course, any test in this field is going to be hard to apply, including de minimis. I mean, what is, and then if you're going to play the de minimis game, you don't have to worry about 51% or 85%, but you do have to worry about 5%. So anyway, I hear Professor Wong saying maybe the percentage approach would be acceptable, but he is always going to focus on the number of choices that are made by the machine. And so I think for him, it might be rare that an AI-assisted work isn't contributing more than 40 or 50 or 75%, right? So it's very hard to actually apply that, because we can disagree factually on what percentage of the total choice set is made by the machine. I just wanted to point that out because it's a fun concept, but very tricky to apply. All right, on your question. Yeah, so for authorless works, for me, I think the answer that would fall out of our copyright system would be that they are not copyrightable. Now, we can all, look at that and say, well, so it looks like Murgis is saying they're in the public domain, et cetera. Not necessarily. An egregious copy of a non-copyrightable work with bad intent, perhaps to get the goodwill of the original creator or to get some of the positive associations with the original creator. You can hear what I'm saying. Some forms of unfair competition in some context might still protect an artist, right? So you say it's not copyrightable. That doesn't mean it's not protectable somehow under some circumstances, right? So I just want to say that we have uncopyrightable works that sometimes can be protected through other theories. And we, of course, in this conversation, we're focusing on copyright, but what I'm trying to say is if people get in the business of creating AI-assisted creations and they think that the copyright rule means you will never have any rights, you can never protect any creative work, I would not go so far, right? Okay, but to get to the copyright question, yeah, I think the natural answer is that they are in the public domain. And I think that's because, you know, for two reasons. One, the machine element we are assuming, and I think it's true and may become more true, is the cheap, easy element. It's not as if AI created works are expensive or difficult. All of you, for preparation for this talk, created multiple AI assisted works, right? So an argument in favor of calling them authorless and not protected is that we don't need protection. These machine decided creations are essentially free, and we can have an essentially limitless number depending on how many prompts we have the energy to type in. Somebody somewhere is going to create a macro that just creates prompts and is going to turn their computer on, and it's going to spit out 27 million AI creations every 24 hours, right? Is that hard to imagine? No, it's not. So that means we don't need copyright protection. The 51% requirement, or whatever the threshold, would be an acknowledgement that the human time and effort is the scarce resource here. It's the one we want to encourage. And to go back to Professor Wong's initial point, it's also the one that copyright was created to protect. And so if we want to have any vestige, you know, of a Kantian individual right approach, then a 51% human contribution should be enough for that work to be protected. That's what I would say. So authorless to me means public domain, subject to my percentage test and subject to non-copyright protection mechanisms.
Obviously, Professor Marges, you are not taking the maximization of output approach. But
No.
if I can just push, follow up with one question, do you think, because you set up this really fascinating theoretical framework, in my view, in your book, 2011 book, Justifying IP. So for you, the IP humanitarian and utilitarian, do you think that would have different opinions regarding my question?
I'm not sure. I don't know. I think I think they might disagree. A utilitarian might say that, of the 27 million works that are created every 24 hours, only a few will be really good. And therefore, the fact that you can create many candidates, they might argue that. They might say you need IP protection, not just to create it, but to promote it and disseminate it and turn it into posters and coffee cups and everything else you might want to do. So a utilitarian, might disagree with that point that some quantum of human creativity is necessary. They might disagree. On the other side, it's hard to know what percentage a humanist IP or a deontological IP theorist would set as the threshold. I would have to think about that. 51% came straight off the top of my head. Maybe there's a case for different numbers there. But I do think that they would look for the human quantum as the core issue. And it could go back even to a definitional point, which is Professor Wong said in our preparatory call, a work is that which is created by human creativity. So you could say that the AI works are not only authorless, they're not works. Under some view, they're not works.
Great. So on this point, I'm going to ask one last question, then we turn to the audience. Really excellent question regarding, whether the derivative work could, So I think Professor Murgis and Professor Wang, maybe Professor Cui, how would you address some argument that I think Beijing Internet Court also made this argument that if we don't grant IP protection for these output, then this might disincentivize the investment by the AI owners. I think either you or Professor Wang, or because in a planning session,
Okay, Professor Wang raised his hand first.
Okay.
Yeah. May I talk a little about the authorless work first?
Oh,
Because
sure.
I think it's very fascinating question. I would like to share you a clip of video.
Oh, the old piano roll.
Oh.
Oh, can you get some sound? It has a great tinny sound.
Okay, I stop here. I think you get my thrust.
Yeah.
This is a little bit spooky, right? There's a piano playing music all by itself without human hands inside. We call it automatic piano. And we made up this mechanical performance as performerless performance. Oh my gosh, it's very mouthful. But the term of the performerless performance only makes sense in the context of the copyright infringement. For instance, if a restaurant wants to use automatic piano to play music, the restaurant has to get the license from a collecting society of the music copyright, right? Otherwise, the restaurant will infringe the copyright of the right owner of the music work, the composer or the publisher. However, no performer's right is rising out of the mechanical performance, because the performance right is reserved for the breathing, living human, to encourage, to motivate the human performers to perform the work. So in the same way, when we talk about the term of authorless work, the term only makes sense in the context of the copyright infringement. For example, if the AI-generated content is substantially similar to a pre-existing copyrighted work, and somebody just uploads that AI-generated content over the internet to communicate it to the world, that act constitutes copyright infringement. It does not matter who creates that content. However, this term does not make sense in terms of the authorship or the copyright ownership, because as just Professor Murgis mentioned a few minutes ago, it's not work at all.
Let me give you an example to clarify it. For example, I copied the Theatre de Opera special that I find that it was very, very beautiful, and it won this art contest in Colorado, and before that was disclosed, nobody knew it was generated through an AI, and obviously it has very high market value, even artistic values, just from the appearance. This is from the look. So that's the kind of situation I talked about. So you think that's no problem, or just in the copyright? Yeah.
Oh, sorry. I can tell you the performerless performance also have great market value. That is, we can see so many restaurants using automatic piano to perform music, but it does not mean that the performerless performance should be protected by the copyright law as a kind of enabling right. And I think it's particularly fascinating to hear the term of the authorless work here in the United States, because I think it took the Supreme Court more than decades to strike down the theory of the threat of law, right? And reinstate the mandate from the US Constitution.
But that's a different, it's related, but not identical issue, right? Originality and authorship. Originality is more about the objective test of the final product rather than the procedure, the control of the procedure, which is the authorship, essentially.
But the mandate from the US Constitution is to protect the author's writing, right? If we say there's a work, but there's no author of it, we recognize that the work is so-called authorless work, right?
With the quotation mark, with the quotation mark, over work.
Yeah, work.
It's not the real work. It's not a real work of authorship, but it has the appearance of a work. If Professor Cui's hand.
Oh, okay. If we recognize there's no author for a work in quotation, and on the other hand, the US copyright law protects such kind of work in quotation, then I think the theory of the threat of law sneaks back to the US Constitution. To the US copyright law. Does it violate the US Constitution, which says that the Congress is only granted the power to make law to promote the author's writing? Is this consistent with the first case decided by Supreme Court?
That's very interesting, very interesting.
Okay.
But I agree that's on the constitutional level, probably. Yeah. Professor Cui.
Okay. Very happy you mentioned the example for the space opera theater's case. For me, that author spent almost 80 hours, right, in preparing that kind of picture. The Copyright Office still says it's not the original one. This could be a routine practice in the future in the United States. That do have caused some problem. I think probably in the future, the user will be forced to really use more Photoshop or like tools to revise this kind of AI generated picture, right? To emphasize it has more human input in this one, and then to avoid this kind of fortune. So I think that here today, Professor Wang still assume that most of users still rely on only AI tools, not Photoshop or like tools. Actually, now the Photoshop and AI tools are merged with together deeply, right? Like the space opera theater's case. The author actually mentioned he used Photoshop to change or to revise the picture, right? So for me, this case shows the problem with the U.S. Copyright Office approach, right? In the future, you could really have too many this kind of authorless works. I think that could be some kind of challenge to the society, but not that serious. As Professor Merges just mentioned, now in the public domain, that's a lot of this kind of works, right? Anonymous works or orphan works, all works has the term of protection has expired. This kind of unprotected work does not cost, even in many cases, very valuable, still very economically or functionally very valuable, but it does not pose too much challenge to the society, right? So I don't really worry about that. But we do have some problems to deal with. For example, on one hand, some people may use AI generate content as his own work, right? This kind of cheating or fraud maybe cause some kind of frivolous litigation in the society. And on the other hand, some AI users, if the U.S. Copyright Office or Chinese court follow Professor Wang's approach, may have difficulty in proving his authorship, right? That problem could happen. I think that we could probably amend or change the existing regime a little bit. For example, we could set for some kind of mandatory requirement for disclosure, right? If you have access or use AI to disclose it to the public. And also probably we could impose some kind of administrative or punitive or criminal punishment for this kind of fraud, right? Make it easier for AI user to claim his own authorship. And then the new technology probably will also help, right? If you use AI, you could record the history of creating this kind of creation process, also help. That's probably the way to meet this kind of challenge in the future. Okay.
That's a
very quickly.
point.
Okay.
I'm sorry about the time limit, but that was a very fair point too, and it corresponds also to the BI, the Beijing court's concern that if just differentiation may encourage hidden information. Anyway, I just want to I'm sorry, we already passed, but just want to use like 2 minutes to address an excellent question raised by our audience. So in your jurisdiction, do you think the AI, the whatever, the human generated through Gen AI or that final output would constitute a derivative work of some of the copyrighted information maybe used in a training? I think he or her, the audience, maybe question is, would that be considered derivative work of that process? If so, would that affect the the copyrightability of such final output? Maybe I'll start with Professor Murgis.
So, yeah, I was just trying to, could you maybe put that one for Professor Choi? I was just looking something up to answer.
Sure. Yeah.
And I'll
Okay.
come back to it.
Okay, I'm happy. I think the prompts is literal, if it's original enough, could be viewed as a literal work. But if AI generate picture based on this kind of prompts, usually I don't think the AI generate picture should be viewed as derivative work of the prompts. It's completely different, right? Because the meaning or the implication of the prompt usually very general, abstract. It does not dictate the expressive elements in the AI generate picture. So my answer is not a derivative work of the prompts.
My understanding might be wrong, but I understood his or her question to be whether it's derivative work of some of the, I don't know, like for copyrighted works during the training. Like, what if, that's the question?
Yeah, that's possible.
Well, we will have a separate session on infringement, yeah?
Yes, we will on the fourth talk. So we'll dive into, but I just want to give maybe a quick, if you can, if it's okay if you can't, but
yeah. I think if the AI generated content is based on an pre-existing work, then the content is technically could be referred as derivative work, but not in the sense of copyright law. The reason is very simple. Even the derivative work has to be work of authorship. There must be an author to create the derivative work. Since, of course, in my opinion, the user is not the author. No author, no work, no derivative work.
good. Okay.
Yeah, I was just looking up some an article on that I saw that was interesting. Anyway, what I come away with is that definitely it's possible for, something in a training set to be so replicated in a final output from an AI system that you'd have to call that AI output a derivative work. I think that is possible, but it does throw you back, onto the basic question. There's very little doubt that in the discretion that the system has, it has enough originality usually so that if we didn't worry about author, certainly the output would be copyrightable on the originality scale. And, for a derivative work, all you really need is some additional original material that modifies or transforms, but still substantially replicates the original work. So, I think it's been the most difficult question so far in the US has been at the initial stage of these copyright infringement suits. Do they survive summary judgment? Do they survive a motion to dismiss? Is there enough there? Is there enough instance of similarity? And I think we have seen some striking similarity. The New York Times published some material justifying their negotiations with the training set people with ChatGPT to try to show that sometimes the output is verbatim pages of New York Times journalism, right? So clearly, there might be small variations. So technically those are derivative works, assuming there's an author, but they definitely meet the test. They definitely would infringe either the reproduction right or the derivative work right, or maybe both.
Yeah, but at least I think the question, another layer would be in the US, at least if something is infringing some work on other rights, and
Yes.
then it can be copyrightable, but
Right.
but not in China. China is, as far as I know, is different in this regard. But
Yes.
so
Yes, unauthorized derivative works have no copyright, unauthorized, which is what that would be.
right. Professor Wang Qian, do you want to say one last sentence on that point in the Chinese copyright law, or
I think I explained that in the preparatory session that in China, the infringing derivative work can still be protected by the copyright law as the original work, as long as it meets this threshold of the originality. So the unauthorized use of an infringing derivative work constitutes another copyright infringement. Of course, if the copyright owner of the original work sues the creator and the user of the infringing derivative work, he can win in the litigation. There's no question of that.
Yes.
okay.
Yes,
Thank you. Sorry.
Thank you so
we
much.
all agree.
Okay. Thank you so much, our fascinating speakers, for such a fruitful discussion. I learned a lot, and I want to also give special thanks to technical support, the wonderful Justin, and also the China IP House to help us to broadcast to the Chinese audience. So thank you very much, everyone. We'll continue the talk series in a month or so. And if you have, I'm sorry that we failed to address all the questions, but due to the time limit. But if you can email me the question, I could direct these questions to the speakers.
Yeah.
Thank you so much. Have a great night, great day. Take care.
Thank you.
Okay,
Thank you,
thank you,
Dr.
Dr.
Hao,
Hao. Thank you,
Thank you
organizing.
so much.
Professor Murdis.